We have two bills up today, as is our custom. After we hear that from testifiers, I'll ask that if there are amendments that are offered, and then we'll go to member discussion and questions. We've allotted 1 hour for each bill. If we are not ready to vote on the first bill at 4 o'clock, we'll lay it on the table, and reconvene tomorrow at 12:30 in room 1100. The same is true if we don't finish the second bill by 5 o'clock. With that, we'll begin with Senate File 3994, Senator Champion.
Mr. Chair, sorry, and Senator Champion, prior to us moving on, thank you, Mr. Chair. Again, we were just served in the previous committee, and the majority seems to have a challenge of getting, we have a 72-hour rule to update right when we post the meeting notice. It's also the rule that it was designed to help provide the information in the actual bill that will be heard in this committee. And yet, again, we have another DE amendment, a delete everything amendment, right? Replacing all the language in the bill. At 4:45 p.m. yesterday, that same language was heard in the House at 8:30 a.m. yesterday. Neither of those meet the 72-hour rule, and it would be absolutely helpful to all citizens who choose to testify that they have the language in which they're going to testify, and we would also like to see that language as soon as possible. And 72 hours gives us enough time for our staff to review those things, and in the sense of transparency and citizen input, it would be nice to get back to the rules, and I hope we could do that from this point forward.
Thank you, Senator Cran. That you have a good point, and we are trying to get things done and submitted as early as possible. And I'm hoping that perhaps you don't have any amendments that needed to be amended on the bill. So if you have amendments, I hope that you follow the same caution and try to get things done early. We do have a little bit of a jam up yet in the revisor's office too. So we will certainly try to comply with what
Mr. Chair, we just came off the last committee that had bills that didn't meet the criteria, and the bills weren't even ready. So you have the ability to make sure, and plenty of flexibility, to bring the bills when they're completely ready. So it would be appreciated by not only the other side, but all of the citizens who take their time to come down here and testify. Thank you.
Thank you, Senator Grant. Okay. Back to Senate File 3994, Senator Champion.
Thank you, Mr. Chair, and thank you to the members. I am excited to be here today to talk about Minnesota Voting Rights Act. And I'll talk a little bit about that after I hope that the committee would entertain adopting the DE to put the bill in the shape I would like, and reflecting conversations we've had with cities, counties, and other stakeholders.
Thank you, Senator Champion. Senator Bolden moves the A2 author's amendment, and conventionally we do approve those amendments. So all in favor, say aye. Aye. All opposed, same sign. The amendment is adopted. Senator Champion.
Thank you, Mr. Chair. Mr. Chair, as I mentioned, I'm here today to present the Minnesota Voting Rights Act, a bill that codifies the protections of Section 2 of the Federal Voting Rights Act into Minnesota law, while strengthening, streamlining, and updating it to make it more efficient, effective, and less costly. As you probably recall, is that the Voting Rights Act of 1965, which the DOJ calls the single most effective piece of civil rights legislation ever passed by Congress, works to ensure that the right to vote and to participate are not denied because of race. This is also the goal of the Minnesota Voting Rights Act, is to guarantee Minnesotans the equal opportunity to vote and participate in the political process. Enshrining these protections into Minnesota law has become especially urgent in light of the recent 8th Circuit decision that upended decades of precedent in ruling that Minnesotans themselves can no longer challenge racially discriminatory laws and redistricting plans under the Federal Voting Rights Act. That's important to understand and to underscore, is because the Minnesota Voting Rights Act will ensure that Minnesota voters continue to have the right to challenge discrimination as they experience, a right that Minnesotans have had since the Voting Rights Act was passed. This bill also improves upon the Federal Voting Rights Act. It establishes, as I mentioned earlier, streamlined and predictable causes of action that will reduce the need for and the cost of litigation. It also improves upon the Federal Voting Rights Act by providing a safe harbor to voluntarily resolve potential violations without litigation, because we recognize the importance of working with political subdivisions as well. But, members, I cannot underscore enough that the time to do this is now. Minnesota has taken great strides to strengthen a system of free and fair elections and pro-voter election rules. We take pride in our strong participation in election administration. But like many of the metrics in Minnesota, significant racial inequities still exist in voting participation, and representation in our political system. Minnesota's history of public and private discrimination against Native Americans, people of color, and language minority voters, and the racial disparities that persist to this day continue to impair the opportunity of Minnesotans to fully and equally participate in the process. Just for context, according to the census, in the 2020 election, 79.9% of non-Hispanic white citizens voted, but only 66.1% of black citizens, 64% of Asian citizens, 62.7% of Latino citizens voted. And while the numbers are not available for Native American voters, the disparities exist there too. As we protect and strengthen our state and local election rules and administration, it's critical that we ensure that no Minnesota voter faces the effects of discriminatory laws or procedures. Minnesotans, and I underscore Minnesotans because I think Minnesotans deserve access to a private right of action and strong legal protections against voter suppression and vote dilution in our state. It is also important to know that we have learned, and I want to highlight that we've learned things from 6 other states that have already adopted state voting right acts. This bill does 3 things. 1, it codifies the protection against laws that would have the effect of suppressing or diluting the vote of a protected class of voters. 2, it provides an opportunity to fix the discriminatory practice or procedures without going to court. And 3, it ensures that the law is applied consistently with Minnesota's history of making voting more accessible. Now, before I walk through the bill, Mr. Chair, I would hope that we could hear briefly from our Secretary of State, Mr. Steve Simon, who's here, to give you some brief words, and then if the chair so allows, then I'll walk through the bill that you now see as a part of the DE amendment.
Thank you, Senator Champion. We have allotted 3 minutes for each person. We'll probably give the Mr. Secretary a tiny bit more, but we'll start out with Mr. Secretary Steve Simon testifying on the bill.
Thank you, Mr. Chair and members. Steve Simon, Minnesota Secretary of State. I'm proud to testify today in support of Senate File 3994. The reason we need it stems from an alarming decision by the U.S. Court of Appeals for the 8th Circuit, which is the federal circuit in which Minnesota sits, along with 6 other states. Here's the history. In 1965, as we all know, Congress passed the Voting Rights Act, one of the most celebrated pieces of legislation in American history. Section 2 of the Voting Rights Act created a remedy for, quote, denial or abridgment of the right to vote on account of race or color, end quote. So it gave people a day in court as a pathway to prove allegations of discrimination in voting. Now, before the 8th Circuit decision at the end of last year, there was never a question about who had the right to bring a lawsuit to enforce Section 2 of the Voting Rights Act. The common and unquestioned assumption nationally was that both the government and private parties could sue under Section 2. In fact, over the past several decades, hundreds of such lawsuits have been filed by private parties, including several that have reached the U.S. Supreme Court. All along, and in all of those hundreds of lawsuits, no court anywhere in America, including the Supreme Court, ever challenged the common understanding and common practice as to who could bring a lawsuit under Section 2. The November 2023 decision by the Eighth Circuit changed all that, ruling for the first time in America that there is no private right of action under Section 2, that only the government can bring such cases. And if the government doesn't want to bring such a case, it doesn't have to, which means that an alleged victim of alleged discrimination has no other way of challenging a law or practice under the Voting Rights Act. Another circuit court in another part of the country recently rejected that same argument, which means that the U.S. Supreme Court is very likely to hear the case and make a final decision on the scope of Section 2. Our office happens to be leading an effort among other secretaries of state nationally to help reverse the Eighth Circuit decision. We believe the case was wrongly decided. But in the meantime, the Eighth Circuit decision is the law of the land in Minnesota. Today, as we sit here, there is currently no right of private citizens in Minnesota to allege racial discrimination under Section 2 of the Federal Voting Rights Act. So we need an insurance policy in Minnesota. If we can no longer count on the Federal Voting Rights Act to allow private citizens to protect their own voting rights, then we need a Minnesota Voting Rights Act to fill the gap. And that's what this bill does. It fills the gap by guaranteeing a day in court for Minnesota voters to defend their voting rights against laws or policies that they believe discriminate against them. It's just about a day in court. And sometimes they might win, sometimes they might lose. But this Eighth Circuit decision has foreclosed that opportunity to them, at least for now. There are still details that need to be worked out. I want to be clear about that. Our office has been involved in many discussions with numerous stakeholders about fine-tuning the substantive language in the bill. And for that, I want to thank the bill's advocates for their flexibility in working with local governments, as well as for the overall leadership of Senator Champion and Representative Greenman in the House. But this bill is necessary to ensure that every Minnesota voter can bring claims, just bring claims, of voting discrimination to court. Inaction is not a safe option. So I respectfully urge your support for the Minnesota Voting Rights Act. Thank you, Mr. Chair and members.
Thank you, Mr. Secretary. We have on our list here Mr. Michael Pernick.
Mr. Chair, if I might
Senator Champion.
continue to put it in context, and then I'll ask the two to come forward and sit beside me while I go through the bill, if that's okay, Mr.
Thank you,
Chair.
Senator Champion. Please proceed.
So we will have Michael Pernick come up and have a seat next to me. He's with the NAACP Legal Defense Fund, and Lotta Knott, who is with the Campaign Legal Center. And Mr. Chair, as they're coming up, I want to make sure that I set the stage because I want to underscore something that the Secretary of State said. Rulings by the rulings by the Eighth Circuit Court of Appeals apply to Minnesota, Arkansas, Iowa, Missouri, Nebraska, North Dakota, and South Dakota. No other circuit have made rulings of this nature, and the Fifth Circuit Court of Appeals upheld the private right of action under Section 2 in a 2023 redistricting case in Louisiana. That's why this is so very important. So as I walk through briefly the language in the DE, Section 1, as you can see, is the title. Section 2 is a set of definitions for various terms that are used throughout the bill. Section 3 is related to construction and use of authority, and this section directs how the state laws and local laws must be construed in favor of the right to vote, as well as how states and local officials must use authority directed to them by law for election purposes in favor of facilitating opportunities to vote by qualified individuals. Section 4.
Excuse me, Mr. Chairman.
Senator Rest.
At what point are you going to take questions for the meanings of things?
I would prefer that we wait until the testifiers are completed. If there's something
Until
that's
the
very confusing,
testifiers?
go ahead and ask.
Seems like to me that if we're going to have clarity in our own minds about the bill, asking questions as we go along as you present it would be very helpful to me, also in understanding the testifiers' either support or opposition to it.
Senator Rest, I think you're correct there. If there's any kind of clarity that's needed.
Making comments.
Thank you.
Under disparity, you asked that it be statistically significant, and what does that mean in the context of this bill?
So,
Senator
Mr.
Champion.
Chair, if I could just do the walkthrough, and then we can get into the specifics, just a walkthrough as to what the bill looks like, and then we can get into those specific questions, just so that
Okay.
we can get all your questions answered, if that's okay, Senator Rest.
Senator Rest, is that
I guess that's
okay with you? Okay.
where you will have to proceed.
Senator Champion?
And then we'll go right to Senator Rest's question. But Section 4, just so that you know, is the substantive prohibitions and the standard for prohibiting voter suppression and the standard for prohibiting vote dilution. Section 5, and again, this is just for context because we'll go through each of these separately and answer any and all questions. But Section 5 provides additional relevant factors that a court may consider when determining when a violation of the law exists, as well as factors that the court is prohibited from considering. Section 6 is the pre-suit notice, and this section requires the potential plaintiff to submit notice to the political subdivision before filing a claim and requires the political subdivision to work in good faith to remedy the issues raised. And Section 7 relates to the procedural matter related to the judicial process that would apply in claims under this act. And Section 8 is a remedy section, and Section 9 relates to fees and costs following resolution of a court proceeding. And Sections 10 and 11 provide permissive authority for statutory cities in Minnesota to move from at-large to ward-based elections if they choose to do so. And Section 12 is the legislative findings that provide evidence of past discrimination in Minnesota and also connects that past discrimination to current public policy and the purpose for this act. And Section 13 is the effective date. That's just a layout of the bill. Now, Mr. Chair, it would be great if we can go to Senator Rest's question, and then we can get into the substance of those sections.
Thank you, Mr. Chairman and Senator Champion. As others, I'm only on page 5 in my reading of your DE amendment.
And Senator Rest,
So I may have
Mr. Chair, we can
other
just ask-
questions later.
Could we ask Senator Rest to move a little closer because we're having a hard time hearing her? And
Senator Rest
sorry,
says great
yes.
word, gentle.
We want to make sure that we can hear.
I will speak louder. I'm only, since I just saw the DE, I'm only at page 5 and reading the bill, but, so I may have other questions later. But in subdivision 2, section 2, where you're defining disparity, what do you mean by statistically significant? What
Senator,
formula are you using to indicate that, sir?
thank you for your question, Senator Rust. My name is Michael Pernick. I'm an attorney with the NAACP Legal Defense and Educational Fund. I focus my practice on voting rights and redistricting work, and it's an honor to be here today, Mr. Chair, members of the committee. Senator Rust, to your question, this definition codifies the weight of authority in federal law in construing racial disparities in voting rights claims. There is ample federal authority in going through evidence and weighing that evidence appropriately. There's no one fixed standard or rule, but this is simply codifying what are the general standards that are used by courts when evaluating these claims. And the two most important, first, any disparity that courts are looking at, it needs to be statistically significant. And the court would make the evaluation of whether something is statistically significant based on the particular facts in those cases. Second, it needs to be a validated methodology. That means if you have an expert witness who's introducing some sort of analysis, the methodology used by the expert needs to be validated, legitimate, often peer-reviewed. So all this is doing is making clear that the Minnesota Voting Rights Act follows these basic rules that are generally accepted by courts so that litigants don't need to fight about them and waste resources and time litigating these questions of what are the guardrails and rules for measuring disparities.
Mr. Chairman,
Thank you, Mr. Pernick. Senator Russ, follow up.
I believe you were answering the question that I didn't ask, but since you brought up the federal laws, in what ways, Senator Champion, and I have only seen this just now and haven't gotten beyond page 5, and I do support the concept and the particulars of a Minnesota Voting Rights Act. I do believe I accept the determination of the Secretary of State that it is needed relative to decisions that are made by federal courts. But can you tell me specifically and where, if at all, the Minnesota Voting Rights Act differs from the federal Voting Rights Act? That's a very important thing to me. Does it go beyond that? And if it does, why? So that's a very general question that needs a specific answer in every section of this bill if it differs. If you can say it doesn't differ, then that's the way I will read the DE amendment. Thank you, Mr. Chairman.
Mr. Chair.
Thank you, Senator Russ. Senator Champion.
I am prepared to answer that question, but I'm going to let Lada Knott answer that question. And if she leaves out anything, which I'm sure she won't, then I will fill in the blanks. So if we could have Lada Knott answer the question, what this bill has that is not a part of the federal voting.
Exactly.
Act.
Thank you very much, Senator Champion, Mr. Chairman.
Ms. Knott, please identify yourself for the record and
course.
continue with your testimony and answer.
Of course. My name is Latha Knott. I am an attorney for the Campaign Legal Center, which is a nonpartisan organization that focuses on defending and advancing voting rights. And to answer your question about which parts of this bill differ from the federal VRA, well, I'll just start with saying that the causes of action that voters can bring have a private right of action to bring lawsuits to challenge voter suppression and vote dilution. That's taken from the Federal Voting Rights Act. This bill streamlines the tests for finding vote dilution and voter suppression from the standards that have been used by federal courts. It also contains 2 new developments that are not in the Federal Voting Rights Act. One is that there is a requirement that plaintiffs give notice to local governments if they think that their rights have been violated. Once they give notice, the local government has 60 days during which time they cannot be sued. And so it gives them a safe harbor there. And if they do adopt a resolution to pursue a remedy, they have 90 days where they can't be sued. This is to encourage cooperation between plaintiffs and local governments and not necessarily skip straight
Mr.
to
Chairman, it
litigation.
would really help me if you would point
Senator Rest.
out in the bill where that language
I'm sorry.
is, as you explained it, and I
Of course.
appreciate your attention to detail. Thank you very much for doing that.
Of course.
Ms. Knott.
All right. When I mentioned the voter suppression and vote dilution causes of actions, those are in section 4 of the bill,
Page what?
page 3.
Pause a second. Okay.
So, Mr. Chairman, so,
Senator Rest.
ma'am, that is the same as in the Federal Voting Rights Act. Is that what you're saying?
Parts of it
It is
parts of it are the same. The causes of action for voter suppression and vote dilution are substantially similar. There are differences in the test. If you're looking at section 4, page 3, voter suppression, and subdivision 1, the cause of action in subdivision 1 is substantially the same. The number 1 and number 2 underneath represent the test for voter suppression. That is a streamlined version. Well, actually, I should say that the Federal Voting Rights Act and federal case law do not actually have a clear legal standard or test for voter suppression. There is one here, so that is a difference.
Keep going.
With vote dilution, subdivision 2, section 4, That is the cause of action that a voter can bring a claim for vote dilution. That is substantially the same as in the Voting Rights Act. Once again, the test, which is underneath, has been simplified in that a plaintiff either has to show polarized voting, or, sorry, I'm probably getting into more detail, but the test is polarized voting, or they have to show the harm based on the totality of the circumstances. So they have to establish harm. And then they also have to set forth a potential remedy that could mitigate that harm. So we've streamlined what's a much more complicated test in the Federal Voting Rights Act and the Minnesota Voting Rights Act. And I can go on to other sections of the bill.
That answers your question, so she's
first-
going through to
Of course.
answer your question.
Yes.
Yes, I don't need to go through every page at this exact point, but if we go
Just the
to,
differences.
Yes, just the
Mr.
differences.
Chairman,
If
from
we
the
go to
Voting
page
Rights,
6,
the Federal Voting Rights Act. How is Minnesota going
Senator
to
Rest.
be different?
Yes.
Thank you,
Thank you.
Mr. Chairman.
yes, if we go to page 6 of the bill, section
It's not.
6, pre-suit notice, continues on to page 7, but that is the section of the bill that establishes a notice procedure. Notice is required for any plaintiffs who feel that their rights have been violated. They have to send a notice letter to the local government, and the local government then has, if you look on page 7, the party that actually sent the notice letter cannot file a lawsuit for 60 days. And if you look at subdivision 2, if the local government works in good faith with the party that provided the notice and adopts a resolution identifying a remedy, then there are 90 days after that where they have to enact the remedy. And also, that's a safe harbor where they cannot be sued by the plaintiff. This is a completely new provision that is not in the Federal Voting Rights Act, because under the Federal Voting Rights Act, if you feel your rights have been violated, your next step is to file a lawsuit to go straight to court. This provides a procedure where the parties can actually attempt to find a resolution without expensive, time-consuming litigation, where they can work together and potentially solve the problem without going to court.
And Mr. Chairman, that language is
Senator Rest.
specifically where that you just referenced?
Page 6.
Page 6,
Is not.
sorry.
So if I may help, Senator Rest,
Senator Kemp.
the notice that she's talking about is on page 6. If you look at page 6, it's line
It's
6.
subdivision 1.
Yes,
Yes.
so page 6, and lines in particular, 6.29.
Yes.
If you look at line 6.29,
thank you.
that's where that notice is. That is a notice that is not a part of the Federal Voting Rights Act. The reason why it was decided to include that is to encourage individuals who have identified a potential problem to notify the political subdivision so that they can attempt to work it out.
Got it.
And here's the other thing I think is important to note, is that the notice is just not a simple letter that you just say, hey, by the way, I think that you have done something discriminatory, but it has to be detailed enough, especially when you think in terms of vote dilution, where it includes a ton of information around past elections, data, just a number of different things in order to really give the political subdivision the background, the information, and so on and so forth, right? And so that is something that is different from the federal notion, right? Let's see. And would you like to go to the next one?
Of course. If we could go to page 9. Section 8, remedies. This section says that if a court finds a violation, they can order the remedy that is best tailored to mitigate the violation, and that they shall consider remedies proposed by any parties and remedies proposed by interested non-parties. And the court may not, the last sentence of that section, the court may not provide deference or priority to a proposed remedy offered by a defendant or political subdivision simply because the remedy has been proposed by the defendant or political subdivision. The reason why the sentence is there, and this is a major difference from the Federal Voting Rights Act, is under federal case law, the local government or the government that is being sued and has lost the lawsuit actually gets deference when it comes to their proposed remedy. And we find that is for a policy reason. We think that is not the best policy, and that the government that violated the plaintiff's rights should not have deference for their remedy. We don't think that the court should have deference for anyone's particular remedy, but should consider every proposed remedy and pick the one that's best tailored to mitigate the harm to the impacted community. So that is a difference.
Thank you, Ms. Nutt. And I think what I'd like to do is I'd like to see us go through the testifiers, as there might be other questions that
Well,
other
Mr. Chairman, was that
persons
the
have.
only differences then?
Pardon me,
Was
Senator
that the
Rest?
only differences from the Voting Rights Act? There's the last one on the remedies on page 9.
So, Mr.
Senator
Chair,
Champion.
I know that my testifier testified to this, but she sort of went past it so that Senator Rest is clear. On page 8, in section 5, these are the factors for determining violations. This was not as clearly spelled out in the federal law, but this is a way for us to grab all those things from the federal law, case law, and put it down as factors for the court to consider. And the court consider any of those factors. And if you look at line 5.30, we also make it very clear that none of the factors in subdivision 1 are dispositive or necessary to establish the existence of a violation of section 200.54, nor should any specified number of or combination of factors be required in establishing that such a violation has occurred. The reason why that language is there, and I can be corrected by my experts, for lack of a better word, is because we wanted the court to have the ability to look at a number of different factors or things that are not there for the court to make a decision based on the totality of circumstances to determine whether a violation existed or exists, okay?
Thank you, very helpful.
Just a couple other little things that I'll tell you that is a little different from the federal one. Is requiring the courts to liberally construe statutes and interpretations in favor of voting rights, because the whole idea is that we want voting rights to be the driver. Providing a stated legal standard for determining vote denial claims, as well as simplified legal standards for vote dilution claims. Codifying the right to claims by groups for vote dilution actions, which exist under federal case law. Establishing guardrails for claims related to polarized voting. Now, that polarized voting language, just so that you see this language, because that is an issue, if you look at page 3, specifically at line 3.29, elections in a political subdivision exhibit polarized voting resulting in an impairment of an equal opportunity or ability of protected class members to nominate or elect candidates of their choice. Now, this is under vote dilution, because now let us explain what vote dilution is and how that polarized notion operates. So I'm going to turn to Michael, who will do that.
Thank you very much, President
Thank you,
Champion.
Senator Champion. Mr. Pernick.
Thank you very much.
And I'm not sure if we did get to identify you, but please do it again so that we can be clear on who's speaking.
Thank you very much, Mr. Chair. Michael Pernick from the NAACP Legal Defense and Educational Fund. So as President Champion said, for the vote dilution cause of action, which is the tool that voters of color have if there's a discriminatory at-large local election or a discriminatory district-based redistricting plan, that's where the vote dilution cause of action is used. The linchpin of the legal analysis in the Federal Voting Rights Act and under this bill is racially polarized voting, looking at whether voters of color tend to prefer certain candidates, white voters tend to prefer different candidates, and if that is happening, are voters of color shut out of representation. For example, imagine a jurisdiction with at-large elections, so no districts. Everybody in the jurisdiction gets to vote for every member of the local city council or whatnot. And imagine this jurisdiction is 30% black and 70% white. And we have voting patterns where black voters consistently support the same candidates, and white voters consistently support different candidates, and usually, or almost always, defeat the candidates preferred by black voters. When we see that happening, that 30% of the population can be entirely shut out of representation on that local board because of the at-large election. So under Section 2 of the Federal Voting Rights Act and under this bill, in that scenario, when those facts are present, there is a possibility of striking down, eliminating the at-large structure, and moving to some other structure like a district or ward system so that voters of color have an opportunity to have some representation, some voice in their local government. So this is nothing new. This has been around since the Voting Rights Act was amended in 1982, and there are well-established standards. What this bill does is it makes these cases simpler and less challenging to litigate. I've litigated these cases across the country under the Federal Voting Rights Act. They often cost millions and millions of dollars. They take years and years to litigate, and they take multiple expert witnesses that end up costing plaintiffs a lot of money, end up costing jurisdictions a lot of money. If the plaintiffs prevail, jurisdictions are also responsible for plaintiffs' fees, which is the case in almost all civil rights statutes. So this is a very expensive proposition, and what state voting rights acts across the country have started to do is simplify those legal tests so it's more streamlined. There are guardrails to prevent costly, extraneous arguments from being injected into these cases so that we can get to the core issue more quickly, more efficiently, and at less cost. And the one last thing I will add to your question, Senator, as President Champion and Ms. Knott noted, there are some areas where this bill simplifies and clarifies areas of federal law, but everything in this bill, all of the provisions of this bill, do come from other state VRAs. Nothing in this bill is new. State VRAs have been adopted now in 6 states. They've worked extremely well in the states where they've been adopted at simplifying and streamlining these causes of action and saving jurisdictions money and resources. And all of the provisions in this bill have been tested in multiple other states, the states that have state VRAs: California, Washington, Oregon, Virginia, New York, and Connecticut. So there is precedent. Other states have tested these provisions, and we know that they work to protect voters of color more efficiently and protect jurisdictions from very costly litigation.
Mr. President, we've kind of diverted just a little bit, and I know you have some testifiers here that have prepared a lot for this, their testimony, and I'm wondering if they have their prepared testimony that they would like to go back to make sure that we're not missing anything that they had planned to say.
Thank you, Mr. Chair. We will do that. So what we'll do is let those others come forward and give their testimony so that we at least give those great folks an opportunity to be heard. And then in the event that we need to go a different day or another day, it'd be great to finish it up today. But if not, we'll be prepared with our other expert witnesses. So with that being said, is Janae Bates around? Oh, she's appearing on Zoom, Mr. Chair, and then Khalid Omar. And so I think the limit is 3 minutes, and if you time them, that'd be great because we want to make sure that we can get to the rest of the testimony.
Ms. Bates, please identify yourself for the record and proceed with your testimony.
Thank you very much, committee and chair. Good afternoon. I am Minister Janae Bates. Many of you know me in my official capacity as the co-director of Isaiah and Faith in Minnesota, or also as a minister at Camper Memorial United Methodist Church in St. Paul. But I am actually joining you today in a personal capacity as a voter and as a proud East Sider in St. Paul. On the east side of St. Paul, I am in Ward 6, Precinct 7, where we are actually identified as one of the most racially diverse wards in the entire state of Minnesota. And we have diversity that spans all across the place. We have a large diversity of folks across ethnicity as well as income, where we do have quite a few lower income neighbors. I am speaking to you all because my ward has also been known as what some may call a a low propensity voter area, but what I like to call it is a high potential voting place. And that is really the difference that makes us high potential, is the fact that, and what makes us high potential versus like high voting impact, most certainly is making sure that we have protected and strengthened our access to the polls and our ability to vote and have our voices heard. And so in Ward 6, where I live and have for the last 5 years, for those last 5 years, there has always been an election every November. And every November since 2019, I have walked 10 minutes to my voting place to go and vote. And I did that in 2019, 2020, 2021, 2022. And in 2023, when I did my 10-minute walk to my voting place, to my polling place, I learned that it was no longer a polling place. I had not gotten notification of that, so I had to pull out my smartphone and find out, go to the Secretary of State's office website and find out where my new polling place was, only to learn that it was actually a 45-minute walk from where I currently was. And so I did walk that because I was fortunate enough to be able to, and then walk to the 50 minutes home. So it took me almost 2 hours to go and vote that day. And I am someone who works in this work and most certainly will do all I can to make sure that my voice and my vote is heard. But it should not have taken that much in order for me to cast my ballot. And I am thoroughly concerned about the number of my neighbors who may have also walked to the poll or drove to their poll that day to learn that their polling place was no longer open, and maybe before or after finding out how long it would have taken them, how far the distance was to their new polling place, did not go. And with very little notice, if any, this was completely unacceptable. And so that is why I'm speaking absolutely in favor of the Minnesota Voting Rights Act. And I appreciate you all listening to my story. Thank you.
Thank you, Ms. Bates. Next testifier we have is Khalid Omar. And Mr. Omar, if you step up, we have to release a chair for you. And please state your name for the record and who you're affiliated with, and continue with your testimony.
Yeah. Good afternoon, Chair. My name is Khalid Omar, and I live in Bloomington, Minnesota. I'm a leader, husband, organizer, and I've been organizing in the Muslim community for many years, educating people about their voting rights and translating for voters at the polling location. Unfortunately, despite having the right to an interpreter at the polls, I have seen elders who pushed every inch to come out and vote, but were confronted with an experience that could scar them from ever possibly voting again. At the polls, they received no support with the language barrier. They asked multiple times for support, and no one was able to help them. They felt humiliated and unsupported. And when they came into the polling location, when I came into that polling location, I heard their frustration in Somali saying, "I knew it. We should not have struggled to come out because this voting process, it's only for certain groups." And when I offered to translate for them, they already decided to go home and not vote. Unfortunately, as much as I would like it to be a one-time thing, we hear stories like this year after year. I don't think that's how anyone here wants someone to feel about exercising their civic duty. The Federal Voting Rights Act was meant to prevent state and local government from passing laws or policies that discriminate against voters on the basis of race or language minority status. But the court have ruled after 58 years that people no longer have those same protection. So this bill would clarify these protections in Minnesota, a state that prides itself on high voter turnout and accessible voting laws, which we absolutely should, and also remaining clear that there are stark racial disparities in who actually registers and turns out to vote. While there are many factors that contribute to this likelihood, it is our responsibility to ensure that discriminatory voting practices and policies are not one of those reasons. I urge you to take stories like those elders and many others there who can't be here today into consideration and pass the Minnesota Voting Rights Act. Thank you.
Thank you, Mr. Cleet. I have one question for you. Which election were you speaking of that you experienced this?
This was the 2020 elections.
Okay, thank you. Next, we have Mr. David Fisher from Clean Elections. And Mr. Fisher, please identify yourself for the record and proceed with your testimony.
Yes, sir. Chair Carlson, members, I am David Fisher. I teach at the University of Minnesota Law School. I'm a former Minnesota Commissioner and Metropolitan Council member, and I now serve as an election judge in Hennepin County. I represent Clean Elections Minnesota, a nonprofit, nonpartisan organization working for inclusive and healthy democracy, and we urge your support for Senate File 3994. Thomas Jefferson described our right to vote as the ark of our safety, the exercise of a right from which all others flow. The Federal Voting Rights Act is a crown jewel of the civil rights era, and as Lyndon Johnson stated in 1965, it strikes down regulations or laws or tasks to deny the right to vote, and specifically on the basis of race. He called it the most powerful instrument ever devised for breaking down injustice. Yet our federal courts are weakening this law, unleashing torrents of state laws, suppressing our vote, subverting elections, and diminishing our democracy. And our U.S. Congress shows little backbone to address it. Well, federal authorities have spoken. Let the states do it. Let states be the beacon of democracy, of fair and free voting rights. And with this bill, Minnesota takes up the challenge. Make no mistake, there is systemic underrepresentation of BIPOC voters of evidence across Minnesota today, based on studies such as that in 2020 by the Reflective Democracy Campaign. It found that in 32 counties, there is a significant gap between the BIPOC share of the population and the BIPOC share of county commissioners. This is a red flag of racial discrimination in voting, of insufficient polling places, as we might have just heard, or district maps that crack or pack voters of color to dilute voting strength. These are precisely the harms the Minnesota Voting Rights Act is designed to remedy. We call on Minnesota to get done what history will judge, prevent voter suppression, and assure full access to voting. And particularly important are the interpretive rules in Section 4 of the bill, protecting the right of natural-born citizens to cast an effective ballot, ensuring this right is not impaired, ensuring that each lawful vote is counted, making this right accessible to all qualified natural-born citizens, and ensuring that protected class members have equitable voting access. Remedying race discrimination is critical, as well as protecting the right of each of us to fulfill, as Lincoln put it, ensuring the government of the people, by the people, for the people. And this is the promise of our democracy. And we want you and ask you to help fulfill this promise. Thank you for your work and commitment to further strengthening our nation and our democracy, and please support Senate File 3994. Thank you, Mr. Chair.
Thank you, Mr. Fisher. Next, we have Ms. Alex Hassel. Ms. Hassel, please identify yourself for the record and proceed with your testimony.
Thank you, Mr. Chair, members of the committee. My name is Alex Hassel here on behalf of the League of Minnesota Cities. I want to first thank Senator Champion for his time talking with local governments to hear some of our questions and concerns regarding this legislation. I would also like to point to the letter submitted in your packet on behalf of cities and counties, which provides much more detail on our position than I'll be able to provide in these short minutes. I'll start by stating that the League is not opposed to a private right of action under a state Voting Rights Act, which before the court decision last fall had been an incredibly important protection for voters for decades. We do, however, have concerns in how the bill as drafted would put local governments in a position of interpreting complicated voting rights law and attempting to provide appropriate remedies. As we've heard in testimony today, this bill is setting a new legal standard for determining whether a voter rights violation has occurred and asking local government officials to analyze these claims and create remedies under those changed standards, which are not clearly defined or understood. We have questions around how the processes and violations in this bill relate to the role of local governments. Cities do not have very much discretion as it relates to how elections are administered. Statute dictates essentially everything from how early cities have to be open for absentee and early voting, how accessibility and facility requirements must be met for polling places, and deadlines and notice requirements for essentially every function that they do. Yet, with how the violations are written in this bill, our understanding is that a local government could be found of a violation under this chapter, even if they are following everything in statute, which indicates implicit but unclear obligations for elections administration. The pre-suit notice process would have nearly all Voting Rights Act claims begin with local governments, but we've only been able to identify a few hypotheticals regarding local actions: polling place concerns, redistricting, and at-large council formations, the latter two being ones that would likely require significant resident engagement beyond the timelines allowed in this section. If this section remains, we would want separation from accusations that are based on state election policy and not on actions carried out by local administrators adhering to state law. We recognize the inclusion of the cost sharing and cap in the amendment, but still believe that having local governments pay for these costs will disincentivize the good faith, easy remedy sought out by this section, particularly because the claim at this point would not have been tested in court to see if an actual violation had even occurred. It seems as though this process, as drafted, is attempting to be two different things: an easy, readily available way to send a grievance to a local government, but at the same time, a legal process. Our understanding of the requirements in Section 6, Subdivision 1, is that there is no legal analysis or study required to send one of these letters. However, we continue to hear that that's an expectation of what would be included in these letters and why there's a cost that would have to be paid by local governments. We hope to continue to work with Senator Champion to find clarity in what that process should look like, how local governments should be involved, and if it should be that low barrier administrative process without legal costs, or if it should be a legal process in which notices are expected to have significant research and legal analysis. I believe I'm at time, Mr. Chair, so I will stop there. Thank you very much.
Thank you. Thank you for summing it up. And now we have Mr. Matt Hilgart from Association of Minnesota Counties. So please identify yourself in the record and your affiliation, and proceed with your testimony.
Thank you, Mr. Chair. My name is Matt Hilgart. It's good to be back in front of the committee. I represent the Association of Minnesota Counties, an organization that represents all of Minnesota's 87 counties. I want to thank President Champion and his staff for his generous time that he afforded us yesterday to talk about this, and his willingness to continue working with us on this proposal. I want to start by clearly stating that we are firmly supportive of the 1965 Voting Rights Act, and we would also be supportive of a clear and concise statement that private right of action is a thing here that should be supported and written into law in Minnesota. To Senator Rest's earlier question, however, we do believe that this proposal deviates and goes further than just saying those two things, which we are all in agreement on. And so the question would be, would there be a form of this that could be 1 or 2 pages stating those things rather than taking national advocates' federal case law, preferred federal case law, and putting it into Minnesota, where a lot of us, election administrators, county attorneys, et cetera, are unfamiliar with some of the terminology and what this might mean in our own systems. I'd like to provide some examples of those concerns, if I may. Section 2 on disparity, this is page 1 of the amendment. Senator Rest reached this before. My first question is, disparity means any variance. What does that mean? That is supported with validated methodologies. What are those methodologies? We're statistically significant. Who validates those methodologies? What is statistically significant? Certainly judges will still have to determine that through case law and cases here in Minnesota. On the second page, we get into construction and use of authority, and this is, again, an unfamiliar part for us, where you're seeing the proposal tell judges what to weigh and what not to weigh and how to weigh those things. It states here, a law, local law, charter provision, ordinance, or local code related to the right to vote shall be construed liberally in favor of these factors. And then it goes to say the court shall exercise that discretion and weigh other equitable discretion in favor of the following. So you're setting up how the court is to look at that evidence. If you turn to page 3, section 4, voter suppression and vote dilution, it says a political subdivision or any other government or entity responsible for election administration, cities and counties may not adopt or apply a qualification for eligibility, any law, ordinance, rule, standard, practice, procedure, or policy related to elections that is likely to result in the following. We are a Dillon law state, and I think that you tell us what to do. In other states, that's not the case, but here in Minnesota, counties are mandated by the state. Local governments have to adhere to what the state tells them to do. We're confused by this. Does this mean we get to openly interpret what laws we think that would be a disparity or would impair someone to vote? Do we get to, at a local level, determine which ones we will either follow or not? We think that might set a dangerous precedent, one that the legislature here might also be concerned about. Then we get into relevant factors determining a violation on page 5. Here we state that there will be 12 relevant factors for determining a violation or 13 other factors that the court may deem relevant. On the next page, it also says the absence of evidence as to any factor does not preclude a finding of a violation. So again, we're telling the court to take these factors into consideration or any other factors you might consider. Oh, and by the way, if there aren't factors listed, you can still create a violation. Now this, again, we share the same goals about local governments, the Voting Rights Act, the importance of private right of action, but here you have us defending these cases. It would be different if the state were defending these cases, but it will be local tax dollars that will be used to respond to violations and defend them. And as Ms. Hassel stated, I actually like the pre-suit notice. I think it is something that potentially could afford a different remedy from the courts to say, hey, we think that you're breaking the law, you're creating a violation of the Minnesota Voting Rights Act, fix it. But in that case, I would ask that you don't punish local governments for actually responding and doing that by making them pay for attorney's fees, which we have been told by national advocates can be quite costly, especially if they're using that statistical significant analysis and can go into tens and tens of thousands of dollars. So again, we do appreciate the goals. We support the Federal Voting Rights Act. We support a private right of action. We would like to continue working with Senator Champion and the advocates to see where those confluence of agreements might come out in a proposal. So thank you for the time today.
Thank you, Mr. Hilgard. We have one more pre-registered testifier, and I think the intent is to try to get done by 4 o'clock, and we're already past that. So I think we'll hear the final testifier. And President Champion, are you available to come back after we do the next bill?
Mr. Chair, I am.
Thank you. Thank you. So what we will do is we'll hear that next testifier. That will take care of all of the pre-registered testifiers, and then we'll lay it on the table, and we can pick it up after we do the next bill.
Thank you, Mr. Chair.
The next testifier I have is Ms. Munira Mohammed. Ms. Mohammed, please identify yourself for the record and continue with your testimony.
Thank you to the chair and members. My name is Munira Mohammed, and I'm with the ACLU, the American Civil Liberties Union of Minnesota. I'm going to keep my remarks very brief. I'll repeating a lot of what's said. So the Voting Rights Act, of course, is one of the most historic examples of civil rights law that this country has, and it's clear that our ability to choose our government is a fundamental part of having a functional democracy. So it's of the utmost importance that all Minnesotans have an equal and meaningful chance to express their voice without obstruction. The Voting Rights Act has throughout the years been attacked and whittled down to a concerning degree. Most recently, as was said, the 8th Circuit Court of Appeals ruled that a private plaintiff cannot assert a standalone claim under Section 2 of the Voting Rights Act. This radical ruling goes against well-established precedents and calls into question the fate of the federal VRA and the protections it offers Minnesotans. At this critical time, Senator Champion's bill gives Minnesotans the necessary state law tools to fight for their rights when violated through a private right of action, prohibitions on voter dilution, voter suppression, and a pre-suit notice for local governments and tailored remedies. It's the ACLU's opinion that this will not open the floodgates to litigation, but rather have a clear and pre-described pathway for resolving voting rights cases. So we urge members to pass this bill. Thank you.
Thank you, Mr. Mohammed.
And Mr. Chair, I'll be
Senator
happy to
Johnson.
wait. Yeah, I'll be happy to wait and see if the other bill goes by quickly.
Thank you. Thank you. So what we will do is we will lay this bill over, we'll lay it on the table until we hear the next bill. And we will pick up on Senate File 3878, Senator Mitchell. And just to move along quickly, we have an author's amendment, the A7. And this was posted on Monday, so we did get a little bit of time for looking at it. And so all in favor of the A7 amendment, please say aye. Aye. Opposed, same sign. The A7 is adopted to Senate File 3878 and Senator Mitchell.
Thank you so much. I'm presenting this bill today to solve the problem in Minnesota of what we call prison gerrymandering, which refers to an imbalance that occurs during the census process, counting individuals as residents where they are incarcerated versus where their residents might have been prior to that. And it impacts districts with high proportion of incarcerated residents who they're allocated to a place where they will never be able to vote, because once they're released from prison, presumably they will go back to their old previous communities or other places. And so it really inflates voting power in some places and can even kind of wreak havoc with how a city counts their numbers. The best example I can give is Moose Lake, for example, where if you look at the population online, it varies between about 2,500 and 3,500, and there is a prison in the area of 1,000. So how do you count the population of that particular town when are you counting the prisoners as the residents, things of that nature. So when it gets counted that way, it can cause a lot of disparity as to how lines are drawn and things like that, where precincts are going to be. Do you cut a precinct where it's a jail and no one is voting, but that's what the precinct size might be? So we're just trying to even that out as we do in other situations with, for example, a student who is out of state but maintains residency with their parents, or a military member who is deployed but would still be counted at their regular residence. And the reason I brought my computer up is to actually list part of the Minnesota Constitution, which says, it is Article 5, Section 2, if anyone wants to look at it. For the purpose of voting, no person loses residence solely by reason of his absence while employed in the service of the United States, while engaged on the waters of the state or the United States, a student in any institution, while keeping almshouse or asylum, nor while confined in any public prison. So a big part of this is also just complying with the intention of our own U.S. or our own Minnesota Constitution in how we are apportioning people when we do the census. The amendment that I forwarded today is because we have been doing a lot of work with DOC to figure out how to do this process. So right now, when people come through the system, there are already addresses collected for about 65% of people. What we have worked with the Department of Correction to work out is that, especially as we get close to census time, they would go through and try and either talk to the person and verify that whatever the address was collected is actually correct, make sure there aren't errors, and if they have one. If they do not have one to put in the system, then much like we would do with someone, for example, for the census who is homeless, they would be allocated to Minnesota, but otherwise their count would go back to the community from which they came prior to their incarceration. So that is the change that we are putting forward today. As I said, we've worked closely with the Department of Correction in Minnesota to figure out how to do this. They have a new computer system coming online in a couple of years. So we kind of extended when we would start doing this by a couple of years because it doesn't need to be done before the next census. And so that they could have the formatting and how they would do this figured out when we would get to that point of collection. With that said, I do have a couple testifiers. I would like to state that Secretary of Simon, and I completely empathize with this, has school conferences tonight. I had to adjust a committee a couple weeks ago for that, very important thing. But we do have the support of the Secretaries of State office on making this change to how we do that data collection.
Thank you, Senator Freeman. I believe we're ready for your testifiers, and I have two on the list here. Ms. Lotta Knott, if you would like to step up and do the, there she is. Please identify yourself again for the record and proceed with your testimony.
Hello again. My name is Lotta Knott. I am an attorney from the Campaign Legal Center, a nonprofit, nonpartisan organization that's dedicated to advancing and protecting voting rights. CLC has been engaged in advocacy across the country to promote democratic reforms and ensure that justice-involved citizens have access to the ballot and fair representation. And through this work, we have seen firsthand the urgent need for reforms like the ones in this bill, which would help to end prison gerrymandering in Minnesota. Prison gerrymandering distorts the democratic process by counting incarcerated individuals where they're incarcerated rather than where their legal residency is for the purposes of redistricting. Elected officials in jurisdictions that house prisons represent large populations of people, disproportionately low-income people of color, who have no connection to the area, who cannot vote there, and who have no friends, family, or community of interest that can advocate on their behalf. Prison gerrymandering artificially inflates the voting power of districts with prisons, while disempowering communities where the incarcerated individuals lived before and where they will ultimately return, their legal residence. And because districts are drawn decennially, these skewed population counts are locked in place for the next decade. Prison gerrymandering also disproportionately harms communities of color in Minnesota. Black people make up 35% of Minnesota's incarcerated population, even though they only comprise 7% of the total state population. As a result, prison gerrymandering in Minnesota denies many communities of color where these individuals are from fair representation. Minnesota has an opportunity to join a growing national movement to abolish prison gerrymandering, following the lead of 11 other states. We urge you to support this legislation.
I need to apologize for calling you Senator Freeman. I was looking at Nicole Freeman's name at the time.
If you pass my bill, you can call me.
Okay.
No, I'm just-
Thank you for that. And now we have Ms. Watana Milikan? Close, okay. Correct me with your first words.
Of course. Hi, y'all. Wintana Milliken.
And please continue with your testimony.
Wonderful. Sorry, give me a second. Awesome. Hey, y'all. So my name is Wintana Milliken. I am a voting rights advocate. I've been working on things at the intersections of voting rights and criminal justice for the last decade. I specifically want to tell a story about my childhood best friend who went to prison shortly after we graduated high school. She spent a few years there and then was released. She's an active member of our community. She went back to the community we grew up in, which is the east side of St. Paul. And she actually was released shortly after a census had been completed. So she ended up spending another decade of being uncounted, which is a problem. Another thing that we know is that majority of folks who are incarcerated when released go back to their hometowns. But if they end up on a chronological timeline that's after a census, can end up being undercounted for 2-3 decades, depending on that timing. And so I'm just here to advocate on folks from my community and folks across the Twin Cities who often get counted in neighborhoods that can be 100+ miles away from their home, and here to encourage every single person on this committee to support this amazing piece of legislation. Thank you.
Thank you, Ms. Milikan.
If I may add.
Senator Mitchell.
Thank you. I apologize. You know, I was trying to get through this quickly in the interest of time and us not being here on a Friday, but I do stand for any questions. Bills similar to this have been kind of being floated around and worked on going back to 2015. I don't always remember every bill I'm a co-author on, but I know Senator Rust had been a co-author on a similar bill in the past. So I think it's time, and as I said, I really want us to comply with our own Constitution, which seems to, state how people should be counted in terms of where they're allocated for voting.
Thank you, Senator Mitchell. I have one question that I've wondered about now. This only affects mapping, isn't that correct? From a census?
Yeah, to a certain extent, yes. So it would reallocate some people, it would reallocate people, back to their home of record, wherever it was in Minnesota. So some places would pick up a person or two, but especially the communities that have, we have prisons up to 2,000 people. Faribault, for example, has about 2,000 people. I mean, how do you draw a precinct around that when no one's voting? So yes, for a large extent, mapping, and then, of course, we have the plan for the people that say they don't have a residence or anything else, that they would still at least count toward Minnesota's numbers when you're talking about things like congressional district.
And those persons who do not have an address that they are affixed to, they get put onto a state count? There's an account that is specifically for them?
Yes, Chair.
Okay, thank you. Thank you. Do we have any amendments? Questions? No amendments? Okay. Questions and discussion. Senator Rest.
Thank you, Mr. Chairman, and Senator Mitchell. One of the supporters' letters says that this bill then promotes the ability of incarcerated people to actually participate in the election, but it really doesn't. It just is where they're going to be counted. So if the majority of people who are imprisoned have a home address in Minneapolis, they're not registered voters because they can't vote. I mean, they can vote when they serve their time, but they can't vote otherwise. Are they counted in any way with voter turnout percentages? Or are the voter turnout percentages only a percentage of those eligible to vote or registered to vote? I mean, when we have 72%, is that 72%, because we're proud of it, of voters who are folks who are eligible to vote? And I really don't know the answer to the question, so that's why I'm asking. Or 72% of those who are registered to vote. And maybe Ms. Stengel knows the answer to that. And then I have another question.
Senator Mitchell, would you like to call a friend?
I would love to phone a friend if that is available. If I had to speculate on the answer, we now register 16 and 17-year-olds, and so your registration isn't necessarily what makes you eligible to vote.
Right.
So my assumption would be that we would not count in people that currently are not able to vote one way or another, even though we do have some people that are registered and obviously cannot vote at a given time.
And Mr. Chairman, just
thank
a
you, Senator
second
Mitchell.
question.
Senator Rest.
The letter and the written testimony from Common Cause, they note with regard to your bill that they support returning to the original bill language in section 15C. And because your amendment, I'm just reading it, requires a strict address match. And I just wonder, what is your answer or defense or explanation of why that change was made? And would you consider responding to the Common Cause suggestion. Do you see the letter I'm speaking of? It's written testimony of,
I'm trying to look at the amendment versus this so I can catch that part of it.
Senator Mitch, I think
I'm
on the.
assuming it was deleted, Mr. Chairman, or changed from the original bill. And I don't have an opinion one way or the other. I'm just curious about your reaction to their criticism.
I might defer to Ms. Frazier, but I will say that, so census data is something that's called geocoded, so that anyone that, okay, so that if you're accessing the data, because of the way it would be collected, it's very hard to geocode because it's coming from the DOC and how it would be turned over to the census. So some of this was just based on practicality. And the balance of, to do it that way would have been such an additional expense to the state, whereas under the amendment, it is still not an exact address, so we're not giving out a prisoner's exact address, but it was done in a collection way that still offers some of that privacy without the geocoding, and it was really, if I remember correctly, kind of it would have gotten almost like out of control expensive if we would have tried to do it the other way. Ms. Stengel or Ms. Frazier, if you have any other.
But Senator Mitchell, I believe we have a person here that can answer some of those questions. Chris Canty from the LCC.
Thank you, Mr. Chair.
Mr.
Chris Canty.
Please identify yourself for the record.
I'm Chris Canty. I am the Information Systems Manager with the Legislative Coordinating Commission. My team is the LCC GIS team, which does all the mapping for the legislature, along with all the other IT responsibilities. And we do process a number of geocodes per year, so I think I can speak to the accuracy portion of what's being discussed here. If you have a specific question.
Do we need to clarify the question?
Sure. I think sure. Well, all I can do is I can speak to the accuracy that's been mentioned there. So I think that was where some of the confusion is. So it's listing, the methods it's using is a Google geocoding service. There are a number of geocoding services out there, but Google has been vetted by us and by a number of academic papers to be the highest accuracy level of geocoding. And so I think the bill mentions that a rooftop or range interpolated would be used. A rooftop would be an exact match against a database of addresses, where range interpolated would take a street segment and divide that. So if 1400 to 1500 and an address of 1450 comes up, it'll interpolate that distance to give it a very precise location. When it fails at that level, it'll go up to a polygon such as a city or zip code or state with a centroid. So when it comes to the accuracy of this is kind of what's being in question that I've noticed, and is what level of accuracy do you want on that? If that makes sense.
Mr. Chair.
Thank you. Senator Mitchell.
So, for example, there could be, if a person lived on one side of the street or the other, we might not have the exact level of geocoding that we decided to do it, and it was a precinct divider, that there might not be that 100% accuracy. But obviously, we've gotten the person much closer to their district, within a few feet even possibly. But if we go to the level that the census is doing, it just would have been much more burdensome than I think anyone wanted to take on to do that. And we also want to be mindful of the costs of doing those things.
Senator Mitchell, have we answered the question? And I have, Senator Swazinski has a question as well.
Thank you, Mr. Chair. Thank you, Senator Mitchell, for bringing this forward. I'm just astounded. I appreciate you bringing up Article 5 of the Constitution, because it just, Article 7, thank you. You didn't bring up Article 5. Article 7, thank you, Senator. I can't believe this hasn't been challenged as current law is unconstitutional in violation of Article 7. And so I guess we've been lucky that in a constitutional way that no one has challenged. So I appreciate you bringing this forward. And if this, somebody in research, has this never been challenged, the constitutionality of it, or the Secretary of State's office? Or, I mean, I'm just shocked that no one has brought this forward in 150 years. But anyways, maybe it's a rhetorical question, but thank you, Senator Mitchell.
Senator Mitchell, more comment?
No, I would just say thank you. And, I think we need to get it in line with the Constitution. As you said, it just seems so clear cut. But also being mindful of incarcerated people as they go back to their communities. As people here said, I mean, you could literally be counted at the prison on April 1st and be released on April 2nd, and now you're not technically part of the count of your community. Yes, you could still go vote and all those things, but you haven't been counted in your community. So I think both from the aspect legally of getting this into line, but also, being respectful of people having, one voice, one vote, and wanting to be counted as part of their community. I think it's the respectful thing to do.
Thank you. Any other questions or comments? I think we're ready to vote. And Senator Mitchell renews her motion to, to pass Senate File 3878 as amended and forward it to State and Local Government and Veterans Committee. All in favor say aye.
Aye.
Opposed? No. The motion is passed, and Senator Mitchell, you're on your way to State and Local Government. Yeah. And Senator Champion.
Mr. Chair, well, Senator Champion's getting ready. We've just barely started the bill that Senator Champion's brought forward. What are your intentions? Are you intending to end at 5 o'clock, or should we just plow through it and wrap it up tonight?
I'd like to see us wrap it up tonight.
Excellent.
Coran.
Thank you, Mr. Chair.
Thank you, Mr. Chair, for welcoming
Senator
back.
Champion.
Thank you to the committee.
I think we can take the bill off the table. And Senator Champion, please continue where you left off.
All right, and just so that we can have a full context, we had all of our testifiers, talk about the bill itself. I will reaffirm that I'm continuing to talk to the Association of Minnesota Counties and League of Minnesota Cities. We know that we're continuing to work through some of the language that's here. I'm just going to ask my other folks to come back. Michael Pernick from NAACP Legal Defense Fund and Lotta Knott from the Campaign Legal Center. We are prepared to answer any other questions that you may have.
Thank you, Senator Champion. Let's see, did we have to do these? Are there amendments from the committee? No amendments. Further discussion and questions? Senator Barr.
Thank you, Mr. Chair. And this might be a I'm not a lawyer, so I don't get how this flows on some of this. So the Eighth Circuit ruled one way. We've got other circuit courts that have ruled other directions. This will probably go to the Supreme Court if I understood what everybody said in the past. What happens with this state law if the Supreme Court comes back and says the Eighth was wrong or right? How does all that fit in and work together? If somebody could kind of explain that to me.
Senator Champion.
Thank you, Chair, and thank you, Senator Barr. I'm going to let my testifier, Michael Pernick, speak to that question because he deals with a lot of federal law in this area.
Mr. Pernick, please identify yourself again and continue with your answer.
Thank you, Mr. Chair, and thank you, Senator Barr, for your question. My name is Michael Pernick. I'm an attorney with the NAACP Legal Defense Fund, and my work involves voting rights and redistricting litigation and policy work. So the Eighth Circuit opinion right now is binding on Minnesota and the other states within the Eighth Circuit. That controls the applicability of the Federal Voting Rights Act, Section 2 of the Federal Voting Rights Act. If that's reversed, that would only affect Section 2 claims, and it's possible that Section 2 claims, if it's reversed, could become available once again to Minnesota voters. It would not affect what the state decides to do. So if Minnesota decides to go ahead and adopt a state voting rights act, that tool would be available regardless of what the Eighth Circuit does, regardless of what other federal courts would do, and it would bring Minnesota into alignment in this with every other state that's adopted a state VRA, where Section 2 is still available in those states, but those states have made the policy choice to codify these same protections into state law, the protections against vote dilution, against voter suppression, so that voters of color within those states have these streamlined, more efficient, clearer rules and legal standards to vindicate their rights under these provisions. So this would remain in state law, and it wouldn't be affected at all by what the federal courts decide to do.
And Mr. Chair, if I can just say that I think it's important to remember that Minnesota is one of the affected states. So because of the Eighth Circuit decision, we don't have any protection at all. And so I just would like to remind us that it's Minnesota, Arkansas, Iowa, Missouri, Nebraska, North Dakota, and South Dakota. And so I just wanted that to be front of mind. Thank you so much for the question, Senator Barr.
Senator Barr, follow-up? Okay, thank you. Other questions? Senator Cran.
Thank you, Mr. Chair. And Senator Champion, when you talked about, the opening statement and the disparities or just the lack of participation by certain groups regardless, so what's the material ability to measure the cause of that disparity? So in here, it implies that you certainly could, by any disparity appears to weaponize the process, one through the Secretary of State and also additionally through the Attorney General's office. How would you make that determination?
Senator
Champion.
Excuse me, Chair and Senator Coran. I'm going to take the first stab at it, then I'm going to go back to my testifier. But just so that we're clear, when we think in terms of the two actions that we are attempting to protect is representation, voter suppression, and also vote dilution. When you think in terms of how do you determine that based on candidates and preference and representation and all those sort of things, there is in the bill information that must be gathered in order to make sure that one is able to make that case. And it's one or more new methods of election to changes to existing methods exist, right? So if there's that benchmark, there's a totality of circumstances that you look at because those are some of the factors that are important. I think it's important to know that it's just not someone making the allegation. They have to prove it. They have to give the information. So there are other ways by which to prove it, and now I'm going to go to Mr. Pernick, who can also talk about undervote dilution. What are some of the things that you have to do in order to show that there's several elections that you have to show documentation for in order to present to the court or even to that political subdivision?
Mr. Chair,
Senator Grant.
And Senator Champion, before we go to the next subject, so as you answer that, then please tell me how you would materially distinguish suppressive activities, right, with dilution or otherwise, relative to voting rules and laws, relative to just the general cultural distrust in government. So it doesn't appear there's any ability to discern the difference here, and each could be then just weaponized and fall within this category. So please describe how that would be
So, Mr. Chair,
determined.
and Senator Coran, first of all, we're not weaponizing. And secondly, there is a distinction between the two. So don't conflate the two. There's voter suppression, and then there's vote dilution. And there's a requirement, the information that you have to present is different. So I'm going to turn to Mr. Pernick, who will walk through that for you as well, just to provide some additional clarity.
Mr. Pernick.
Thank you, Mr. Chairman, and thank you, Senator Curran, for your question. As President Champion said, there are two distinct causes of action, and this bill provides two streamlined legal standards by which courts can evaluate in particular facts whether there's a violation. I believe your question about disparity measures, that is most relevant to the voter suppression cause of action. So if I may direct you to page 3, line 3.16, that is the legal test for voter suppression. And it provides that there is a violation when a plaintiff shows that a particular action or decision made by a local government results in a disparity in voter participation, access to voting opportunities, or the opportunity or ability to participate in the political process. Now, a baseline racial disparity does not make a violation. What a plaintiff would need to demonstrate is that there's a relationship between a particular decision that's made and a racial disparity. So let me give you an example. Let's say that we have a black community that has had access to a polling place for a decade, and voters are used to voting at that polling place, and that polling place is closed. What you would need to do is convince a court that that closure of the polling place would have a causal relationship with the reduced ability of voters of color to be able to participate and vote. And when these sorts of cases come up in federal court, courts generally expect validated methodologies and statistically significant data to verify that there would be harm to voters of color. So what does that look like in this hypothetical? It might mean that you would have an expert witness who would calculate driving times, or who would look at who participated in the past and measure the increased burden on those voters in the future, and do a racial analysis to see if that closure would result in racial disparities. There are validated methodologies that courts use to evaluate these sorts of questions. Expert witnesses across the country have experience evaluating whether something would result in a racial disparity, and they're robust and significant. So what this would do is really just import those standards that are regularly litigated in federal court and give some clarity that this is the legal test, this is the legal standard that courts should evaluate to see if there's a violation and if there needs to be a remedy, such as opening up another polling place in that community so that voters of color don't suffer from the same sort of racial disparity that's been demonstrated.
And do vote dilution.
Oh, yes. Thank you, President Champion. So the vote dilution cause of action similarly lays out a streamlined legal test that is, again, drawn from principles and ideas in federal law. So if I may direct you to 3.27, this is where the vote dilution cause of action is laid out. And as I mentioned earlier, the linchpin of federal vote dilution claims and the linchpin of claims under this act is a showing of racially polarized voting, or polarized voting as it's termed in this legislation. And again, a plaintiff would need to demonstrate and satisfy a court that there is a pattern, a systematic pattern of voters of color preferring certain candidates, and as a result of the structure of elections, the configuration of district lines, those voters of color are outvoted and denied an equal opportunity to elect candidates of choice because of structures that are in place at the local level, such as at-large local elections, or the configuration of a district map that might crack communities of color. And this is not done just in one time, based on one election. Experts generally look at least 3 cycles, sometimes many election cycles, to confirm and persuade and show to a court that this isn't a one-time issue, that the method of election systematically and structurally denies voters of color an equal opportunity to elect candidates of their choice.
Thank you.
Senator Crane.
Mr. Chair, and so with that, you described the judicial process, right? If you choose to go and seek that remedy. But are there cures? Because we talked about reducing the cost and going to the Secretary of State, which then could, in what the average person understands, rulemaking, could impose a remedy just because they choose and to write law without the legislature, because that cure is described here, because that would be the first level or first opportunity if they so choose, or to go through a lawsuit. So could the Secretary of State cure that claim of any of those issues you just described, dilution or otherwise, if brought forward and through rulemaking?
And Mr.
Senator
Chair,
Champion.
can I take the first stab, and then we're going to go back to Mr. Pernick? So the first thing I think is important to understand under this context is what we're doing here in Minnesota that is not being done or wasn't done on the federal level is the pre-suit notice. That's first and foremost. No matter what it is, what you're alleging, you have to notify the political subdivision. And that notice can't just be a letter just saying, I think you're discriminatory. You have to provide detailed information, analysis, expert generated information in order for the political subdivision to do what? Look at it and determine if they feel like they are doing something that is problematic or not. Now, if that political subdivision and the others agree, great. They just say, okay, let's discuss what needs to happen in order to remedy this problem. Now, if, let's say for an example, within this, once this notice is given, and let's say for an example, and I can be corrected on this because this is a little hairy, that there's an upcoming election, and that 60 days that is required under the pre-suit notice rule, let's say within that prescribed amount of time, an election is going to come up. It is under those limited circumstances that you're able to then try to talk to the Secretary of State or someone by which to help look at whether there's a perceived challenge or problem and what can be done within short order in order to remedy that. And it could even be the court, because you could directly go to the court as well. But Mr. Pernick, can you correct me where I'm wrong and also point to the place outside of page 6, which is the pre-suit notice, which is on line 629 going forward?
Mr. Pernick.
Thank you, Mr. Chairman, and thank you, Senator, for your question. As usual, President Champion, I do not need to correct anything. Everything you said was absolutely right. Senator, to answer your precise question of whether there's any circumstance in which the Secretary of State could mandate or require any remedies, the answer is no. That is not provided under this bill. There are really 2 main ways, procedural ways, for a remedy to a violation or potential violation to be adopted. First, as President Champion said, if a pre-suit notice letter is sent and the jurisdiction receives that letter and says, this makes sense, I think that there's an issue here, the jurisdiction can voluntarily choose to adopt a remedy. And I'll get to how they do that in just a moment. So that's option number 1, if the jurisdiction wants to fix the problem voluntarily after they're put on notice. And option number 2, if they don't, and the prospective plaintiff says, oh, I still think there's an issue here, they can go to court. And if the court agrees with the plaintiff, just like the Federal Voting Rights Act, the court can order a remedy at the conclusion of the litigation. So those are the only 2 ways that a remedy can be adopted. Now, on avenue number 1, there may be some isolated circumstances where, because of structures of state law, a jurisdiction does not have the flexibility to voluntarily adopt a remedy. For example, for certain jurisdictions, there isn't a voluntary authority under current state law to go from at-large elections to a ward-based system. So what this bill does is it, first of all, if I could direct you to page 10, line 10.4, this provision gives jurisdictions that flexibility to voluntarily change their ward boundaries. So it gives them that jurisdiction or that autonomy to voluntarily fix the issue. Going back for a moment, and I apologize for flipping back and forth, but going back for a moment to page 7, line 7.1, or 7.10 rather, these are the approval procedures if we're in a circumstance where the jurisdiction doesn't have that flexibility. Subdivision 3A refers to administrative deadlines. That's really about polling places. If you are, let's say, within a month of the election, the jurisdiction under state law doesn't have flexibility to change their polling places, but if they receive a letter saying, wait a second, there's a black community that doesn't have access to a polling place, they can request approval from the Secretary of State to waive the deadline for adding a new polling place so that they can add that polling place before the election. That's what this does. It's just administrative timing deadlines, and that's the only authority that's given to the Secretary of State under this bill, is to waive those sorts of administrative deadlines. If, for instance, it's something like an at-large election that is problematic and they don't have the flexibility to voluntarily move to a district-based method of election, under subsection B, under subdivision 3, starting at line 7.22, they can go to a court, and instead of litigating a whole expensive lawsuit, they can submit a petition to a court saying, we want to voluntarily fix this problem. Could you give us approval to do so? And the court would need to agree, yes, there's a potential violation here, and here's the approval to do so. So these are procedures to enable voluntary resolution, but there's nothing in this that would authorize any mandated changes by the Secretary of State. It's all if the jurisdiction wants to fix the problem, or if a court determines that you have to fix the problem.
Thank you. Then, so when we talked about, thank you, Mr. Chair. Then we talk about the proof and evidence, right? All of the factors which would enable these to move forward. And then but then it really gets concerning when you look at 6.3. The absence of evidence to any factor does not preclude a finding of a violation. And so we get a little bit worried when, well, we think we've gotten here, but then if you haven't met the evidence, that still wouldn't preclude them from finding resolution or imposing it upon, and those things worry me as well.
Mr. Chair, I'd like to go to Ms. Knott.
Thank you. So to your point that the absence of evidence as to any factor does not preclude a finding of a violation, this section, which is on page 5, it's section 5, relevant factors for determining violation. This is a test called totality of the circumstances. And the idea of it is that you have various factors that a court can consider, evidence that's relevant to the determination of whether a violation has been committed or not. And none of the factors on this list are dispositive. They are all things that can be considered. And the idea of the benefit of the totality of the circumstances test, as opposed to like a bright line rule, is that it gives the court flexibility to consider many different types of relevant evidence and then come to a conclusion as to whether a violation has occurred or not. And that's why it's not a checklist where one would need every single factor on the list in order to find a violation. It's something where you can consider all of the contextual evidence and then make a determination.
Thank you.
I should also mention that this is actually the standard that's used by the Federal Voting Rights Act. We're codifying factors that are present in federal case law that courts evaluate to make these determinations.
And Mr. Chair, if I could just say one
Senator
thing.
Champion.
Is that the totality of the circumstances is something the courts use, not just for voting, but for other areas of law. So it's not just something that is being thrown in here, this is something that the court always pretty much uses, whether you're talking about EJJ factors, whether you're talking about stop and search issues. There's just that totality of the circumstances is something that the courts use on a regular basis.
Yeah, thank Senator Corrad.
Thank you, Mr. Chair, and thank you, Senator Champion. Senator Champion, help me out with the scenario. If somebody could bring cause of action, we just recently had, and I agree it wouldn't be one election, but multiple elections. So the city of St. Paul now has an all-female city council. Would a person, a male, in a protected class in this legislation, could that potentially bring cause or bring suit? And how would that look? And what would the remedy be?
Thank you.
Senator Champion.
Thank you, Mr. Chair and Senator Corran. One of the things that you have to be clear on, especially based on which section of the law that you're using in order to bring this claim, especially under vote dilution, you have to show several different elections. It can't be just one election. So it can't be like, oh, well, this time, this is what happens. You have to demonstrate a pattern and a number of different things that's going on. So, and you then also make the determination as to whether that election violated the rights of any protected class person, right? You know, but again, let me go to Mr. Pernick just to make sure that what I'm saying is accurate and true.
Mr. Chair, and so Senator Champion, so with that, so 3 elections occurred, still have all-female city council.
I'm not sure.
Senator Champion.
So let me take you to.
And males, protected class males, just don't feel that their vote matters. What's the cure for that? Do they have cause to bring a case forward?
So let me be very clear with, so Mr. Chair.
Senator Champion.
Senator Corran, if you talk about white males and white males.
I'm talking a protected class. I'm talking anybody in the protected class as defined in this statute or this proposed set of statutes, bring forth and say, of the protected class, I'm not talking about white males, bring forth and say, well, I feel disenfranchised and something must change. Under this, it appears they would have cause, remember, after 3 elections, they would have the ability, after 3 elections, come forward and say, my vote, I feel disenfranchised. What's the cure?
So,
and do they have cause to bring forth the suit?
So let me be clear. So I was going to, Mr. Chair, and to Senator Corran. First of all, if you look at protected class under 2.9, right, if you go to 2.9, where it articulates clarity as who are the members of the protected class. Gender is not on this list. So the answer to that portion around gender is no. But you have to look at the notion of protected class.
We have a question from Senator Westland. Comment, Senator Westland. Okay, you pass. Okay, Senator Corran.
Mr. Chair, I'm good for now.
Okay. Any other questions? Questions or comments? Senator Matthews.
Thank you, Mr. Chair. Just going off some of that discussion, I still am troubled by the language that are in here. We talk about the legal process that we have to go through and we have to provide evidence. Senator Corran pointed out one of them, any other factors and the absence of evidence doesn't preclude a violation still seem like pretty wide open statements to get around that. The other one that I want to point out is Mr. Pernick, you went through the process of what has to be proven, but the section right before what you discussed is section 3 that says that anything that we bring under this section has to be liberally construed in favor of voting rights. I imagine that current suits today have to be weighed against what is the evidence, what is the law, what is the Constitution, make a determination. And this feels like a slanting of the field that we are uphill from the get-go in favor of one particular side. And so how does that jive with you're bringing, you say you have to bring a long list of things, which I don't read in the text of the bill before us. And then right ahead of that, we have that anything brought under this section is liberally construed in favor of the factors listed in this section. How do you jive those two together?
Well,
Senator
Mr. Chair
Champion.
and Senator Matthews, I'm going to take the first run at this, and then I'm going to go to Mr. Pernick again, because you specifically mentioned him, and he'll be able to talk through that. So the first thing that we want you to understand under 6.3, when you look at 6.3 and you're going to the absence of evidence as to any factor does not preclude the finding of a violation, what that means is not any particular one factor. So we want to make sure that that language is clear, because what we've been saying is that there's a totality of circumstances, excuse me, that there's a number of factors the court can consider, and they're not weighted factors. And so we just wanted to make it clear that this is not a checklist, because sometimes people see a list of factors and they start doing the checklist. So I want to make sure that we are really clear there. It's not saying the court should not have information or evidence that would lead it to believe that a violation has been committed. Secondly, liberally construed is really think about the whole mission and the whole idea for the Voting Rights Act, is because there's historic discrimination that has said that there are times that certain groups of people, protected class, have been, barriers have been created, and we want to avoid that because our democracy, counts on that. So I want to now go to Mr. Pernick, who can now speak to that issue much more specifically and correct me if I'm in error or if he wants to embellish on anything that I've talked about.
Mr. Bernie.
Thank you, Mr. Chairman, and thank you, Senator, for both of those questions. As President Champion said, on your first question, the line, the absence of evidence as to any factor does not preclude a finding of a violation. This is consistent with how the totality of circumstances factors have been applied and weighed in federal law. This is all drawn from a 1982 Senate report, U.S. Senate report, that was given serious consideration and codified into the case law by a 1986 U.S. Supreme Court opinion, Thornburg v. Jingles. So this is drawn from that body of federal case law, and it's just codifying it into Minnesota law so that litigants and parties have clarity as to what the rules of the road are when these cases are litigated here in Minnesota. And all this is saying is there are 13 factors listed. If you only have evidence on 12, that doesn't mean you lose. It's all considered under the totality, and the absence of evidence as to any one particular factor does not mean that you lose, that you're out of court. To your second question, if I may, to your second question on the, let me refer to the specific section, under Section 3, Construction and Use of Authority. So I want to clarify, this section is only applicable in a scenario where there's an ambiguity in state law, or where there's an area where judges are already afforded discretion in interpreting or applying laws. And we have, whenever there's an ambiguity, something called canons of statutory interpretation that are generally broadly used. And one of the canons of statutory interpretation, when you have an ambiguity, is something called the democracy canon. This is the principle that when you're interpreting ambiguities in laws that relate to the right to vote, you should construe those in favor of the right to vote, because there's a policy determination by courts and by many state legislatures that the right to vote is fundamental, and when there's an ambiguity in state law, it should be weighed pro-voter as opposed to anti-voter. So this is saying, this is codifying that principle into Minnesota law, and it's actually quite consistent with how Minnesota courts, some Minnesota courts, have interpreted laws relating to the right to vote. I could direct you, and I'll put into the record so we have it as part of the record, a 1914 opinion of the Minnesota Supreme Court, Silberstein v. Prince. The statute is 149 Northwest 653. The pin site is page 654 of that opinion. And that case talks about an ambiguity in state law and how courts should evaluate those ambiguities. And it says, when there's this type of ambiguity, there's a principle of interpretation that we should weigh it in favor of the voter. Now, that principle hasn't always been followed across the country, so an increasing number of states have codified that canon of statutory interpretation and that rule that judges should follow when evaluating and using discretion around the right to vote. an increasing number of states have codified that into state law, and that's what this provision would do. It would say it's a policy choice that when courts are evaluating these ambiguities, it does not relate to weight of evidence or admissibility of evidence. It does not relate to the substantive factual determinations. It's really about statutory interpretation and judicial discretion.
Thank you, Mr. Chair. Appreciate that info. So back to page 6.3 then. I appreciate your response. So what I'm hearing you say is your intent is that you basically mean that the absence of evidence as to any one factor does not preclude a finding of a violation for any other factor. Would that be an accurate characterization?
Mr. Pernick.
Thank you, Senator, for that question. I would say the absence of evidence as to any one particular factor does not preclude a finding of violation. That is, I think, a fair way to interpret that sentence.
Senator Matthews.
Mr. Chair, thank you. Then I would recommend potentially modifying, amending that line to say that, because my reading of the words that's here now sound very loose-ended. I think if you're trying to get at precluding, lacking in one factor is not precluding another factor would be more clear. Otherwise, the plain reading of what we have here is, though, if you don't have evidence and you feel like you want to, just go ahead anyways. This is why I'm glad we're having this question and answer here where I'm drawing some of this out. Unless you can tell me that the sentence right here is verbatim to the Federal Voting Rights Act and has the case law to back it up. Otherwise, I think you want a little more guardrails on here that shows we're trying to keep within the context of what factors that we are talking about. So I'm seeing heads nod. Maybe I'll just make that oral amendment, Mr. Chair, to change the line. Maybe council can help me state the absence of evidence as to any one factor does not preclude a finding of a violation to any other factor, unless council has a recommendation of tightening up that verbiage with something else.
And while, Mr. Chair, while council is looking at that, I'd like the council to consider the line and just tell us the absence of evidence as to any particular factor does not preclude a finding of a violation. I think that's cleaner, and I think that gets to what I believe that Senator Matthews is putting forward.
Senator Champion, council has some notes on this.
Okay.
And Senator Champion, with your suggestion of particular, would you, what's your thoughts on that, on adding that?
I'm sorry?
What's your thoughts on adding, if we add particular factor?
Yeah, oh, no, we would see that as a friendly amendment.
Now, this does have to go to judiciary yet, too. And Ms. Stengel will read the what she has come up with here.
Thank you, Mr. Chair, and Senator Matthews, please correct me if I've got this wrong, but the motion would be on page 6, line 3, after the word any, insert 1, and on page 6, line 4, after violation, insert for any other factor. So the sentence would read, the absence of evidence as to any one factor does not preclude a finding of a violation for any other factor.
Senator Champion.
If I might, I think by adding the latter of for any, well, I think once you get beyond violation, I think that sort of sounds a little confusing, because the whole idea is to say that there's not one, that the absence of evidence as to any particular factor, like, so let's say, for an example, in the scenario given, that they found that there was 12 out of the 13, that not to have that 13th factor does not preclude the court from finding that there was a violation. And I thought that's what you were saying, as opposed to what I think the latter part of what council was saying, after the words, after the word violation.
Senator Bolden, comment.
Thank you, Mr. Chair. I would propose, Mr. Chair, given that Senator Champion is very willing to work on this language and with Senator Matthews, and there's, certainly some work to be done there rather than wordsmithing in committee, given that maybe I think it's good to have this discussion. I would propose maybe you continue to work on that since it is having another stop in judiciary.
And Mr. Chair, to that recommendation, we are committed to, wanting to work with Senator Matthews as we are still continue to work with cities and counties, because our objective is to have the best piece of policy that we hope that would become law that would benefit us all. And so if Senator Matthews is willing to work with us on that line, we would certainly do so.
Thank you, Senator Champion. Senator Matthews.
Thank you, Mr. Chair. Well, the reason for having committees is to wordsmith bills like this. I would ask that we consider adding this, and you stated maybe particular is better than one. I think that, that sounds fine to me. I still am not sold on, not having anything after the word violation on 6.4. But I think if you wouldn't mind sticking some form of amendment in the bill, that way we have it tabbed and red flagged as we are moving through and we figure out if we're ironing this out, any particular. So I guess I'd make my oral amendment as council read, on line 6.3, after any, insert particular. And after 6.4, the language that Ms. Stengel read prior, which I'd need her to read again.
Senator Champion.
Mr. Chair, I'm willing to, and I hope that committee would be willing to accept the word particular after any. I think when you add the rest of Senator Matthews' language, it then comes across a little more confusing. So if we added particular today, we'll continue to flesh that out with you, but I think it comes across a little confusing once you add the words after violation.
Any other comments? And are you making that as an amendment? That Senator Champion, Senator Matthews offers the amendment to. In fact, maybe what I should do is have Council Stengel read it again.
Thank you, Mr. Chair. The oral amendment is on page 6, line 3, after any, insert particular. On page 6, line 4, after violation, insert for any other factor.
And Senator Champion, is this something you would accept or as a friendly, or would you prefer we change that? So,
may I have just a second, Mr. Chair? Mr. Chair, I would ask this, if Senator Matthews would consider us us breaking out the proposed amendment, like for us to vote on particular and then as a separate motion, adding or proposing the additional language after violation. It's just breaking it up, separate, division of the motion.
Okay. Senator Matthews, Senator Champion offers to divide your motion. Yes, Senator Champion, you can't make that.
No, I'm asking him to. I know I can't make it. I'm asking him just to divide it.
Okay, Senator.
Because we are, Mr. Chair, we are fine and think it's clear, and it gets to what he really wants by adding the word particular. It's just that the other words just seem to confuse the sentence.
Okay. And anyone on the committee can make the motion. Senator Champion is not on the committee, so what we need to do is make the motion to split the split the amendment?
I would like to make the motion to split the amendment.
It's not, yes, so the motion is, so you say the motion is divisible.
Yes.
So you say that?
Can I say that?
Yeah.
Yes, the motion is divisible. Now, I think,
Senator Matthews gets to decide which piece. to
yes,
vote.
and Senator Matthews, you get to decide on which one we vote on first.
Mr. Chair, let's vote on particular first.
So the motion is, if we add a particular on line 6.3 between the words any and factor. All in favor, say aye. Aye. The motion passes, Senator Champion. We're going to, we're now.
You didn't take no votes on that.
I didn't, oh, I'm sorry, I didn't take any no votes on that, yes. Okay, I thought I heard a unanimous, yes. Yeah. So are any negative votes on that? Any no votes? No, none. Called it right. So anyway, now we're on the second part of the Matthews Amendment.
And what we would ask is that the committee not do the second part of the amendment, but I will still make a commitment to work with Senator Matthews to see if there's language that would be clear, because council and others are like,
okay,
that's a little unclear.
Senator Matthews renews his motion to add the, for any other factor after, before the period on 6.4.
Mr. Chair.
Senator Matthews.
Just to wrap it up, I guess I'm not understanding why you don't think that's clear. I think it reads clear to me to say any particular factor does not preclude a finding of a violation for any other factor. I hope that we do continue to work on it. I still do ask the committee to pass it because I think that does make it clear. If it does not go on, I do hope that the author continues to work on it, but I don't see what his reason is for saying that he doesn't think it is as clear. We might just agree to disagree on that, and that's okay. But at this point, I still would urge support of this second half.
And Mr. Chair, we will, it is our
Senator
commitment,
Champion.
if it doesn't go on, we will still continue to work with Senator Matthews, because I have two attorneys on my side, and I'm a lawyer, and they're still both coming up with two different things in order to make that clear if we add some additional language. So I will continue to work with you if that doesn't go on.
Thank you. So we have renew the motion. It's to add for any other factor before the period on line 6.4. All in favor, say aye. Aye. All opposed? No?
No.
Okay. Do we need the division? I'll do division. I don't want to just proclaim.
I'll make
that.
from it, division.
Okay. So all those in favor of the motion, of the Matthews motion, please, I think we could just raise your hand. And we have Senator Port, who is on, who's online. You have to say whether or I can see you, so you can raise your hand whenever you'd like. So, okay, we have the clerk count the hands, please. Don't get tired.
Could the nays raise their hands, please?
There being 6 ayes and 7 nays, the motion is not adopted. And Senator Matthews, I think what Senator Champion has committed to is something that we'll commit to as far as my committee offering that we'll work on that. So thank you for your motion.
Thank you,
Senator
Mr.
Matthews.
Chair. Thank you. And I will look forward to doing that work. The last things I wanted to ask about is Section 5, these factors. How many of these 12 delineated factors are, if not verbatim, at least in large part, substantially similar to the Federal Voting Rights Act?
So, Mr. Chair, we'll go to Mr. Penner.
Senator Champion and Mr. Pernick.
Thank you, Mr. Chairman. Thank you, Senator, for your question. These factors are all drawn either verbatim or close to verbatim from that 1982 Senate report, which was endorsed and embraced in the 1986 opinion Thornburg v. Jingles, or from other federal case law. So these factors are drawn from existing federal cases. And at the end of the day, this assessment, it's really an open-ended totality of circumstances assessment. So again, no one factor is dispositive. It's really supposed to give guidance to litigants and to courts as to the general flavor of evidence that should be considered when making this assessment. So none of these factors are dispositive. It's just giving that sort of guidance to courts and litigants.
Senator Matthews.
Mr. Chair, thank you. So let me just ask the biggest one that sticks out to me. And so, maybe if the testifier would be willing to email out these cases, these citations, I definitely would like to follow up and read them. Number 5, use of overt or subtle racial appears in political campaigns or by government officials. And let me just come out in this toxically charged political environment that we're unfortunately in right now. Some people I hear on TV claim "Make America Great Again" is overt or subtle racial appeal in a political campaign. Someone going to have a private right of action over a disagreement over a overt political campaign like that? And if not, what is the purpose of something like this? It just sticks out in a very strange way of how certain voices talk about this in this sometimes toxic political environment.
Senator, Mr. Pernick.
Thank you, Mr. Chairman. Thank you, Senator, for your question. So that factor at 5.13, that factor is drawn almost verbatim from the 1982 Senate report that was endorsed in the 1986 United States Supreme Court Thornburg v. Jingles. It's looking at whether there is evidence of overt or subtle racial discrimination in campaign messaging as probative of whether there's something happening in the jurisdiction that warrants judicial intervention. So what is overt? Obviously, that's if there's an explicit racial appeal, something that's racist or discriminatory said within a campaign. Subtle racial appeals that federal courts have acknowledged look at sort of dog whistle issues. So if, for example, there's I'll give a specific example. I litigated a Section 2 case where a candidate used images of gang members of a particular race and said these gang members are associated with my political opponent, and a federal court ruled that that sort of evidence was a subtle racial appeal because of the context and the way that it was used, and experts who were able to weigh in and say that sort of evidence is a racial appeal in campaigns. So that's an example of a subtle racial appeal. There's no circumstance in which a racial appeal, even if it qualifies under this factor, would give anybody a private right of action. This is just one of many considerations, and courts again have to consider the totality of the circumstances under all of these factors or other evidence that gets to this question of whether there's systemic racial discrimination or harms that communities of color are suffering that requires some sort of judicial intervention to ensure that there are fair rules for those communities.
Senator Matthews.
Mr. Chair, appreciate that. Your example, though, I could easily see being copied and pasted over in today's environment. I mean, it would be, I guess, according to who is my question. Who has the strike zone? Because I could see someone copy and paste that language verbatim that you just said against a candidate today that they just don't like, and they want to say they're their image, their literature, their TV appearances are that dog whistle, that trying to raise animus. So who has the ultimate strike zone in here? That's what I'm still trying to wrestle with in seeing this proposal to add into state statute.
Senator Champion.
Thank you, Mr. Chair, and thank you, Senator Matthews, for the question. I'll take the first bite at the apple, the judge. And it has to be more than just one factor. I know, Senator Matthews, I would encourage you to appreciate, which I'm certain that you will, is that these are several things. It's not one thing. So I can't just come up with one allegation and then use that as the basis to now go to court. I can't. It doesn't work that way. But who has the strike zone? It will be a judge who would have the strike zone. Now, if Mr. Pernick or Ms. Knott wants to weigh in further or correct me if I'm wrong, but that's my understanding.
So briefly, Mr.
Thank you, Senator Champion.
Briefly, Mr.
Senator
Chair,
Matthews.
and thank you for your indulgence. So Senator Champion, where does your language say that it needs to require more than one factor? I read any of the factors at the top of the list. Where is it saying you're going to need more than one of the factors?
Thank you, Mr. Chair. Senator Matthews, if you look at line 5.2, in determining whether under the totality of circumstances, a violation has occurred with respect to a protected class, a court may consider any of the following factors. And remember, any of them, you can't just choose one. The court has to weigh a number of different things. So there's no way a person could just use that as a singular notion and go to court. There's all these other things that has to be shown and done based on the Federal Voting Rights Act, as well as what we're trying to implement here in Minnesota. Anyone else, if I'm wrong, if there's something else you want to say?
Mr. Pernick.
And thank you, Mr. Chairman. Thank you, Senator. Very briefly, the key phrase that governs this is the phrase totality of circumstances. So courts are directed to look at all of the circumstances, all of the relevant evidence, and really get in to understand what's happening in the jurisdiction. And it's that phrase totality of circumstances that directs courts to consider everything that's relevant to the assessment, not just one thing.
The only thing that I would...
not.
Thank you, sorry.
State your name for the record and then go.
Letha Knott, for the record. The only thing that I would add to that is that you're looking at the totality of the circumstances, you're looking at how many factors, but also how severe particular factors are. So with the example that you gave of Make America Great, is that a subtle racial appeal or not? Like there's, if that's the only factor that you have, and that's the only piece of evidence you have for that factor, that's not a particularly strong case under the totality of the circumstances. So it's the number of factors and also the severity of various factors.
Senator Anderson.
Thank you, Mr. Chair. I'm looking at line 5.21. What does it mean, the extent of polarized voting?
Mr. Pernick.
Thank you, Mr. Chairman. Thank you, Senator, for your question. So the concept of polarized voting is has long been called the linchpin of vote dilution cases. That's the statistical analysis of whether voters of color tend to, over the course of multiple elections, vote cohesively for particular candidates, and whether the majority tends to, over the course of multiple elections, vote cohesively for different candidates to deny voters of color the equal opportunity to elect candidates of choice. As we spoke about earlier in the hearing, that example of the at-large jurisdiction, that 70% white, 30% black, the 30% black voters tend to support particular candidates under the at-large election. The white voters vote as a bloc to deny black voters any opportunity to elect a candidate of choice. And even though the jurisdiction is 30% black, we have an all-white a board that's elected solely based on the preferences of the 70% white voter. So in that scenario, That's where you would have polarized voting. All this is saying is when courts are doing the totality of circumstances analysis, one of the many factors that they can consider is whether there's evidence of that polarized voting in that jurisdiction. So it's simply saying that same sort of evidence that's the crux of the vote dilution claim and has long been accepted by federal courts, that's relevant under this totality of circumstances evaluation.
So, Mr. Chair.
Senator Anderson.
Senator Champion, so you've stated earlier that it would take like 3 elections to verify that there is a factor of extent of polarized voting. Am I correct in saying that?
Mr. Chair, Senator Anderson.
Champion.
Yes, that's my understanding, and we can go back to Mr. Pernick, who does a lot more work in this area, but that's my understanding.
Mr. Pernick.
Thank you, Mr. Chair. Thank you, Senator. So that's generally correct. Courts hearing federal Section 2 cases generally expect experts to be able to point to at least 3 illustrative elections where there's some level of racially polarized voting. In practice, though, it's often more than that, but it really depends on the data that's available for the jurisdiction and the information that the expert can evaluate. But that's a general benchmark and rule of thumb that political scientists who do this work generally say that you really should have at least 3 different contests, election contests, that you're measuring to see if there's evidence of polarized voting.
I'm going to tell you that right now we're almost at 5:30. That's a half an hour past what we thought we would do. And there's some members that have commitments, so we have to either lay it over for tomorrow or vote on it. And what I'll do is I'll ask Senator Rest to be really brief with her question.
I'm just following what you've said about that any means, in a sense, more than one. So if that sentence read, a court need consider only one of the following factors, that is what is intended with the rest of this. I'm not asking for an amendment, because the word any can mean more than one, obviously. But it's intended in this list that the court would not just, or be free to consider more than one factor, but would not be limited by saying it need consider only one, right?
Senator Champion.
Mr. Chair, I think I understood what you were saying, and are you back at the 6.3? Is that where you are, Senator Rest? 5.4. Or are you at, are you at 5.4?
I'm at,
Senator Rest.
I'm at 5.4, just because that was the sentence that Senator Matthews was looking at. I'm just trying to understand where the limitation is. And by saying any, that can be more than one, but they also they would only need to find one. Am I understanding that language correctly?
Mr. Pernick.
Thank you, Mr. Chairman. Thank you, Senator, for your question. So generally, this is intended to follow the weight of authority in federal case law.
Just answer my question. You can say yes or no. It's okay. I'm not going to pursue it.
Yeah. So it's flexible. It's generally more than one, I think, is how a court would interpret that.
Thank you.
Thank you, Senator Rest. And we have one closing comment from Senator Cran.
Thank you, Mr. Chair. And Senator Champion, you know, we've had a good, lively debate here today. I understand you guys have an amazing faith in the judicial system. You're all attorneys. And the average layperson, I don't think, does. I think there's so many good merits in here, but it also appears to be completely weaponizing in many, many different ways, and just a new platform for a new level of lawfare that we've seen all throughout. you've talked about, right, this is pro-voter, pro-participation, pro-representation, and maybe pro-representation, the only way to solve that would be, maybe we have to mandate it, right? National Day, holiday, maybe we could get it back to where people could be a true belief in the election process. Nothing that's been done in this entire process will enhance the transparency, trustworthiness of the process or openness of the process. Because at the end of the day, neither Republicans nor Democrats have trusted the results on our major elections. And so we've seen a complete weaponization, activist judges, all of those things have come into place. And so to me, this looks like, as a non-attorney, looks like a heaven for civil rights attorneys. Basic things, when our citizens find out, when they actually learn what's been done over the last 12, 14 months, our election laws have become less transparent. We used to have the ability to do independent validation to ensure only eligible people could cast ballots. Those things are now no longer public, no longer able to do those things. When we close off the transparency and we add all this complexity, it's not building trust. And so we've got to figure out a way to collectively, all of these things bring them together where we're building trust. The rules from what was passed in the last legislative session haven't even been released yet to the public. We're into the 2024 election season. Unfortunately, I don't think any of this builds voter confidence, and it appears that the lawfare, which is fully engaged and appears to be pretty heavy and one-sided, that it's going to further create a lack of trust because it does nothing to build upon that. We want to make sure that everybody can vote, that it's easy but really hard to cheat. And there isn't a single person in this room that can say the changes we've made are going to make that possible. So thank you, Mr. Chair.
Thank you, Senator Grant. We're going to vote now. All those in favor say aye.
Wait.
Oops. So Senator Bolden moves Senate file, which one is it, 30? No, it's the other one. Okay, yeah, Senate file 3994. All those in favor say aye.
As amended.
Aye. Oh, I'm sorry, as amended.
And where's it going?
And it is going to state gov. State and local government and veterans. And it will go to judiciary after that. So, we do have more time to work on it. So thank you very much. All those in favor say aye. Aye.
Aye.
All opposed?
No.
The ayes have it. Senator Champion, you're on your way to state gov.
Thank you, Mr. Chair, and thank you, committee.
With that, our business is done today, and I hope, and I was looking around, and I think we have Senator Limmer on judiciary. So we can load all these amendments that you'd like to have him present in judiciary. So, meeting adjourned.